This past month, May 20th, 2024, the Occupational Safety and Health Administration, OSHA, published its final rule for the revised Hazard Communications Standard, or HazCom, or HCS. This in order to conform with updates to similar regulatory schema in Canada and under the United Nations. We're going to talk about this on this episode of the OSHA 3030 on June 26th, 2024. I'm Manesh, Rath, and welcome to the OSHA 3030. Well, hello, everyone. I'm Manesh, Rath. I'm an attorney at the law firm Keller and Heckman here in Washington, D.C. And for about 28 years, I've been engaged in the practice of management side, occupational safety and health law, and other areas of workplace law. And I'm joined today by my colleague and friend, Taylor Johnson. Taylor, welcome to the OSHA 3030.
Manesh, thanks for having me.
Well, we got an important topic, and hundreds of people have registered for the live webinar. This is being pre-recorded, I should point out. I shouldn't use the term live webinar. This is being pre-recorded on Monday, and we'll be broadcasting it on Wednesday. So we will not have a off-the-record section.
Right, that's right.
But a really important subject, important to employers in all sorts of manufacturing sectors associated with chemical manufacturing, plastics manufacturing, petroleum, et cetera, of incredible importance. And on an everyday practical basis, this is how hazardous chemicals get communicated from one employer to another. So let's talk about what we're going to talk about in today's program. I think we should start off with giving a little bit of background to this final rule that just got published.
Yeah, how we got here, essentially. And then we'll go into this idea of classifying the hazards of a chemical based on the downstream reactions that could occur. Reasonably anticipated reactions is the word. So a lot of talk about that, and we'll get into that in today's program.
And we'll talk about how this final rule aligns with Canada's standard as well as the globally harmonized systems that's put into practice in Europe and in various versions elsewhere around the world. I think we should also talk about the changes to the confidential business information. We've addressed this issue in the proposed rule.
Yes.
And that would have been probably the October
It was
2023
correct
episode of the OSHA 3030. Okay.
Yep.
And a lot of these issues came up. I encourage you all to check that out as well.
Yeah, and another one that we also talked about was some labeling changes, especially for small packages. So we'll cover that, and then safety data sheet changes as well. So how this new rule is going to impact your safety data sheets and your labels in your workplace moving forward.
It's a final rule, and they've created an implementation schedule. So we'll talk about that as well, and then finish up with a discussion of practical takeaway items, what employers should do in light of this really incredibly important new rule. So why don't we get into it? The background of the Hazard Communications Standard as revised in 2024. This rulemaking has its origins going back to 2021.
Yeah, about 3 years ago now. Yeah, February 2021 is when the proposed rule, the notice of proposed rule was published in the Federal Register. Again, this is the HazCom Standard, 1910.1200 for all those of you familiar with the codes and the regulations out there.
Yeah, Section 1200, where HazCom's always sat. So they proposed the rule in February of 2021. They went through a comment period and then held a public hearing in September of that year.
Yeah.
Not a lot happened after that.
That's right. Yep. I think took some time. OSHA did. There was more than 170 public submissions. So, aggregating all of those and considering them. And then on May 20th, just about a month ago now, the final rule for the HazCom Standard was published in the Federal Register.
Well, I think we should start with maybe what is one of the biggest or most impactful changes to the 2024 version, viz. The 2012 HazCom revision.
Yeah, it's this idea of downstream reactions. So you can see here, the 2012 rule, excuse me, for each chemical, this was sort of the obligation of the manufacturer importer. So as it stood, they had to determine the hazard classes and where appropriate, the category of each class that apply to the chemical being classified. So pretty much a straightforward obligation there. And then Manesh, you juxtapose that with this final rule, which includes this 2012 language, but then goes on to have this whole additional language here.
That's right. The agency talks about the responsibility to identify any potential changes in the chemical's physical form during its reasonably foreseeable uses, chemical reactions included, provided that those chemical reactions or changes in the chemical's physical form are reasonably anticipated changes through reasonably anticipated uses or applications of the material being manufactured. Now, that's always been part of the interpretive understanding of HazCom in the 2012 revised version as well. This is now baked into the written language in the standard that did not exist before in the written standard itself. And it leaves an open question. I think that that is part of the challenge that employers will face, is that the open question is, to what degree can you expect a change in the chemical's physical form or a chemical reaction to the product to be reasonably anticipatable?
Yeah, that's exactly right. I think, the term reasonably anticipated is not defined and certainly open to interpretation. When as the manufacturer, as the importer, will OSHA determine that it was reasonable for you to anticipate a particular reaction, I think is an open question. And does it need to be in writing, for example? Does there need to be, what's evidence here reasonably anticipated? I think is going to cause a lot of concern. And you certainly saw that in the proposed rule, where several commenters expressed this concern, and that this would shift a burden from them as a manufacturer to a downstream, shift the burden, excuse me, from a downstream user back to the manufacturer for sort of being on the hook for knowing or reasonably anticipating, I guess now you could say, these chemical reactions.
Yeah, and the problem is some chemicals are highly usable in a flexible large number of different arrangements or uses. And so you can conceivably not have any idea of the complete set of changes or chemical reactions that your chemical will be, or theoretically could be, put to use for. But if it becomes common in the marketplace, it's foreseeable that somebody will ascribe that knowledge to the manufacturer, perhaps unfairly, that this would have been reasonably predictable because, after all, it's being put through these chemical reactions in such large volumes for a particular application. But it's not really easy for a manufacturer of a chemical, particularly if it has a high degree of utility, to be able to keep up with all of the uses that particular chemical might be put to by downstream users.
Right.
And that creates a real challenge for manufacturers, given this language. OSHA has said, well, the intent of, and they said this in the Federal Register announcing the final rule, they said the intent of the new language is not to require manufacturers or distributors or importers to predict how downstream employees will be exposed to a chemical, but just to classify the chemical for hazards that arise through known or reasonably anticipated uses. That sounds like it kind of doubles back on itself. It's the agency said that the manufacturer is not required to predict how employees will be exposed to a chemical in every conceivable use. They merely need to classify a chemical based on what is reasonably anticipated. And that leaves an employer with very little by way of clarity as to understanding the degree of data clarity, or the degree of how definitive data is about downstream usage, such as that it would trigger a duty for the employer to say, yeah, that's reasonably anticipatable now.
Yeah, I completely agree. And you've seen this already in the trade press. A few trade associations have come out and said, that OSHA failed to consider the costs of evaluating reasonably anticipated uses, that this could result in increased costs and, safety data sheet and labeling software, and that they're just left with no real explanation as to what reasonably anticipated means. And so I think it's something to keep an eye out for in terms of, potentially a challenge to this rule moving forward.
Well, it's a fair point that just to make sure everyone's caught up, one of the requirements for the agency when promulgating a new rule is to undergo an economic analysis of what the cost of compliance would be. And so if this idea of trying to reasonably anticipate downstream uses has been miscalculated, then that would be a failure on the agency's part, potentially, in undergoing a rigorous economic analysis. So that's a fair argument and maybe a fair complaint, given that they haven't been clear even in their explanation of an unclear regulatory language when they say, we're not trying to require you to predict everything. We just want you to predict what's reasonably anticipated.
Yeah.
So without any explanation of what's reasonably anticipated. I think the other problem with it, potentially, it leaves the agency exposed to the potential for challenges, is that when you look at the difference between the proposed rule and the final rule, as a matter of administrative law, the agency is not permitted to digress from the proposed rule in the final rule format so greatly, so substantially, that the new rule didn't afford a fair opportunity to stakeholders to comment because they didn't see it coming based on a much changed original rule. And that, I think, is another problem for this particular rulemaking with respect to this idea of reasonably anticipated uses downstream.
Yeah, exactly. I think you would have seen comments like we're seeing now, which is, can you define reasonably anticipated? Can you give examples? Can you give more guidance to the regulated community on that? And the fact that that term came up for the first time in the final rule, I think is, you make a great point there, Manesh.
Yeah, and so we're going to have to figure that out as time goes on. And this is one of those painful predicaments that the employer community is left in because of a lack of clarity in rulemaking, that it may take a long time to sort out what perhaps administrative law judges or the review commission or courts believe to be a better, more precise or clearer definition of the threshold below which something is not reasonably anticipatable. And how much knowledge can be reasonably attributed to a manufacturer about downstream uses. I'd also point out that the same goes for upstream uses. The challenge to a manufacturer is to get enough information about what's going to happen to its material, and the downstream purchaser may not be willing to divulge that information that would enable a upstream manufacturer to be able to adjust the information communicated in their hazard communication standard communication pieces, like the safety data sheet or the label.
Yeah.
This is, after all, the kind of use to put to a product that may have proprietary value. And it's not necessarily any of the manufacturer's business, if indeed there is proprietary value to the downstream consumer as to what they intend to do with the product. That may actually be the secret ingredient in a trade secret formulation or confidential business information in a downstream formulation. And thus, the upstream manufacturer may not have the opportunity to force disclosure of enough data to be able to make that calculation or estimate.
Yep, that's a great point.
Let's talk about some of the elements of the new hazard communication standard that were changed in order to align with other standards around the world.
Yeah, so first, in alignment with Canada's Workplace Hazardous Materials Information System, or WHEMIS. In particular, OSHA here focused on small packages. So small packages will now have special labeling provisions in two specific scenarios for 100 milliliters or less, or 3 milliliters or less containers. I think the key thing to point out here is that this applies when the chemical manufacturer or importer can show that it's not feasible to use things like, pull-out labels or fold-back labels or tags that would sort of interfere, with the transportation, with the normal packaging. Then you're able to use some of these exemptions that'll be now in the new paragraph F1 of the HazCom standard. But there's one, Manesh, for packages 100 milliliters or less.
Yeah, we deal with a lot of manufacturers of specialty materials that the individual packaging is so small that the label
Right.
far outsizes the packaging. And this is, I think, for those manufacturers, a welcome sort of additional piece of clarity for how they could comply.
Yeah. So for 100 milliliters or less, you have to put the product identifier, pictograms, your name and phone number, and then a statement that the full label is available on the immediate outer package. And then for 3 milliliters or less, no label is required, but the container must bear the identifier of the product. So those are the specific changes with respect to those two size quantities.
Globally harmonized systems just underwent revision 7. Every time OSHA gets around to revising the hazard communication standard, GHS has revised its standard 2, maybe 3 times. So GHS revision 7, in order to conform with that, the OSHA HazCom Standard 2024 has changed with respect to some of the specific hazardous properties like skin corrosion or irritation, serious eye damage or irritation, and chemicals corrosive to the respiratory tract. One in particular, skin corrosion and irritation, the HazCom 2024 indicates that animal testing is now prohibited, which is the case for GHS and has been for some time.
Yeah, exactly. Or should be avoided at all costs. There's this tiered evaluation in the new Appendix A, and you're not going to use that animal testing pretty much in all cases. And that's, like you said, exactly the way that it is in GHS 7. So just something to take into account when you're evaluating those hazard classes is to, when you go to Appendix A, there'll be this new sort of tiered evaluation. This is when you're trying to determine the hazard class. You know, is it category 1? Is it category 2? And so you'll be going through there and making those steps. And, you know, based on GHS 7, there'll be some changes there now.
There have been revisions to the physical hazards definitions in Appendix B for flammable gases, desensitized explosives, aerosols. One interesting change, they've stricken language relating to pyrophoric gases and updated that particular hazard, pyrophoric gases, in their Appendix B to conform with Revision 7 of GHS. This is, I think, a significant change for those very specialized manufacturers who deal with pyrophoric gases. Aerosols, much more commonly present in the workplace. OSHA has updated the chapter to align with Revision 7 and added that non-flammable aerosols would be categorized as Category 3 flammables. And they've made changes as well to oxidizing solids and to desensitized explosives. It's important if you're in a manufacturer or a user dealing with those kinds of substances to make sure you understand what those changes are so that you can either address that in your safety data sheet or understand the changes that are going to be found on the label or safety data sheet from your suppliers.
Yep.
I think one of the other challenges that we talked about in our October program is the use of confidential business information or trade secret information and how to deal with those when identifying the hazardous ingredients in a safety data sheet. Up until an interpretation came out earlier in the year, 2023, if I recollect, this was an area where some employers would leave wide ranges, like this particular ingredient is a trade secret and it's anywhere from 1 to 20% of the total formulation.
Right. And then I think also grouping was another issue that we saw where, you know, you'd list the main ingredient in a substance, in a mixture, and then just, you know, say proprietary information, one line item, and really that would be, you know, 4 or 5, 6, you know, different substances. So OSHA sort of clarified that in this new HazCom rule. There's a prescribed list of concentration ranges that you can fall under, and then each individual ingredient in Section 3 of your safety data sheet needs to have a line item. You can claim it as trade secret and you can give these prescribed concentration ranges, but you can't group them all together in the aggregate.
Right. And this prescribed table is going to be a safe harbor if you intend to identify any specific ingredient. Each ingredient has to have its own line item and its own assignment of one of these value ranges.
Right.
And then if there's multiple trade secreted ingredients, they each have to have their own line and their own assignment of one of these ranges to them. That's a big change. It's again reflective of an interpretation that came out in the early first quarter of last year, if I recollect.
Yep.
Time flies, so I could be off by a whole year. But because that is already out there as an interpretation, this is merely codification or standardization of a position that OSHA has taken for about a year now.
Yep.
So that's confidential business information. A lot of considerations when trying to determine whether or not and how to identify confidential business information or trade secreted ingredients on your safety data sheet. We work with a lot of manufacturers on those kinds of questions.
Yes. Yes.
Let's talk about labeling.
Yeah, so just a few, specific labeling changes that were clarified in this new rule. So the first is that you're allowed to use the exclamation point now for hazards not otherwise classified. I think employers were left in sort of a gray area in terms of determining what pictogram to use for hazards not otherwise classified. So OSHA came out and said you use the exclamation point pictogram for that now. And then with respect to Department of Transportation, DOT, OSHA in this rule says that the pictogram is not required on a label when under DOT regs, you're already required to have that same pictogram. They call it a placard in the DOT regs, on the package. So you don't need to double down essentially if under DOT regs, it's considered a hazardous chemical and you're going to go ahead and put the placard on. You don't need to do that again on the label.
This is an important and valued relief, I think, because when you look at the container that contains the immediate container that contains the product, it usually goes into a bigger container and then goes into the trucking container, and that allows a little bit more latitude for shippers.
Yep.
And I think it comes up again when the changed label requirement, the deadline for the change label requirement gets put into effect. We'll talk about that when we get into the implementation schedule.
Yep. And then just one other quick thing on the label is that the responsible party that's listed, I believe that's up in section 1, or excuse me, just on the label, usually up at the top, the responsible party.
But you're right, there's also a responsible party in
The safety data sheet,
Right.
yeah, needs to be a U.S. Address and phone number. We've come across this question over the years with some of our international clients that we advise, and so to comply under the OSHA HazCom standard, it does need to be a U.S. address and a U.S. telephone number.
Not only that, it has to match
Yeah,
the safety data sheet and the label. There may be additional information, by the way, but there also has to be matching information for the responsible party.
exactly.
The reason this comes up and that we've dealt with it a lot is you get a lot of international manufacturers who let's say manufacture a product in the United States. Some of the product is going to the United States markets, some going to Canada, some being shipped to Europe, or you might have a European manufacturer that manufactures the same ingredient in Europe and manufactures it as well in Canada. Some of the Canadian product goes back to Europe, some of the European product goes to the United States or Canada. So it can be very confusing. Now, here's where it gets complicated. A lot of manufacturers don't know where their product is going to end up.
Right.
So to comply with this requirement can be very challenging for those manufacturers. They might sell their entire product volume to a distributor, and that distributor decides whether it's going to the United States, to Canada, or to the European markets, and not the manufacturer. And that makes it very challenging to comply with this idea that the label has to have a responsible party address and phone number for a party in the United States.
Yep.
As well, if they're using agents like distributors, they may not have an office in the United States, not even a sales office in the United States. That distributor may have the sales office in the United States.
Right.
So these problems have to be addressed. You have to figure out you're going to solve this challenge for your own individual circumstance based on how your product moves. We've, as you say, worked with a lot of manufacturers, and we're happy to take a look if there's any challenges that we can be of any assistance with. But I think that is also going to be one that manufacturers are going to have to settle out over time. I will point out, however, that is also a reflection of interpretive guidance in the form of interpretation letters, in this case, going back quite
Yep.
a few years. And so in that sense, it's not brand new. It is merely a standardization of an interpretive position that OSHA has taken through letters of interpretation over the years.
Yep.
Should we talk about additional changes to the safety data sheet?
Yeah, I mean, we just covered the address and telephone number. Just to go back to, our discussion about reasonably anticipated hazards, I will say that these, when you identify those, if you are going to make changes, that you need to list those in section 2 of the safety data sheet. But OSHA has said that you do not need to put those reasonably anticipated hazards on the label. I think we would argue that the safety data sheet and the label should match for a variety of reasons, but you will find that in the notice that it only needs to go on the safety data sheet. So we at least wanted to point that out just from a perspective of reading the rule.
Right. If it is a material for which there are exposure limits or a permissible exposure limit under OSHA, that should be included in section 3 of the safety data sheet. I think that's an important development.
Yeah. And then section 9, properties, there's new calculations to determine the boiling point of flammable liquids and accompanying storage containers. And so just if you're in that specific, if you know your chemical is, is going to be one of those, make sure you keep an eye out for that. It's new section 9.
So the best we can cover in a 30-minute program, that is the highlights of the changes to the HazCom system under the 2024 revision. Let's talk about the implementation schedule that OSHA has carved out.
Yeah, so you can find this in the rule. And essentially, they break it down under the affected party. So if you're a chemical manufacturer, importer, distributor, or if you're an employer, and then they break it down by, is your chemical a mixture or just a regular substance? And so there's a tiered compliance date period. I think important to point out that from July 19th, 2024, when the rule takes effect, until 18 months after publication, all affected parties, employers, importers, manufacturers, everyone can comply either with the new standard or the 2012 standard. So there's sort of a grace period for everyone until 18 months after publication is the first trigger that you need to look out for.
I think this is important that you mentioned that there's a staggered deadline for mixtures. We raised this concern with the agency, and many manufacturer concerns raised this issue with the agency for the 2012 revision, and they still haven't taken it with the sufficient degree of seriousness that the manufacturer community intends it. And that is this: there are mixtures that require updated, compliant safety data sheets in order to revise the safety data sheet for the mixture. So that's why OSHA has given a staggered deadline for mixture manufacturers. However, there are mixtures that are the result of mixtures as well. So if a mixture contains ingredients that led to updates in a safety data sheet 18 months after the publication of the rule, and the mixture manufacturer takes all of the subsequent 18 months, then the purchaser of that mixture that uses that mixture to mix into other mixtures will have run out of time with respect to the 36 months after the publication of the rule. And indeed, there are several levels of mixtures of mixtures of mixtures, complex chemical formulations that would require that many levels in the stream of commerce have already completed their revised safety data sheets and updated labels in order for that more complex or advanced mixture manufacturer to be able to use that data to effectively revise their own safety data sheet and label. And that is a really large problem for one of the most important sectors in the American economy and one of the most complex to be able to comply with this when there's only two levels, one for ingredient manufacturers and one for mixture manufacturers. It's just an oversight of something that is not only quite clear and obvious, but indeed has already been pointed out to the agency. And so it's an unfortunate omission of a real opportunity to provide a different kind of scheme that would have provided a greater degree of clarity, relief, and an ability to reasonably comply with the rule had there been a more sophisticated structure for implementing these compliance requirements over time for mixtures of mixtures of mixtures, for example.
No, that's a great point.
Well, that's the implementation schedule, and I think it's important for all of you to keep your eyes on and to calendar your whole team to make sure you're on target. I think the first thing employers should do in light of this final rule is to develop a plan for meeting these key dates. Yeah. Part of that may require that you communicate with your upstream ingredient suppliers or mixture suppliers and make sure that they're going to get you something ahead of deadline so that you have enough time within deadline to do something effective with the data that your upstream suppliers are providing you with.
No, that's a great point. Next, I think, changes to the safety data sheets or to labels, should also necessitate changes to the other elements of the HazCom standard that, the regulated community has to provide. We all know it's not just safety data sheets and labels, it's also a written communication plan and training. So if you change your safety data sheet or you change your label, to make sure that, you change your written communication plan and update your training materials accordingly so that they're all in unison with each other.
That's right. And it may require different kinds of engineering controls or personal protective equipment
right.
as well, based on revised safety data sheets that come down the line. And so again, the need for making sure that you're communicating with your upstream suppliers to get that information as early as possible and not at the end of the regulatory deadline for your upstream manufacturers to comply with. Finally, I'd say, well, I think there's a few more things we want to point out, but these ingredients that do have, they have either trade secret or confidential business information in their composition, that those should be separated out. Each ingredient that's a trade secret or a confidential business information should be separated out on its own line, and that you should use the date range, the data ranges or the percentage ranges in conformance with the guidance that was issued a year ago, and that has now been standardized in the new rule. I think that's an important development because that's going to probably take some time for manufacturers that have a large number of product lines that have confidential information ingredients.
Right. And then finally, I think, like we talked about, it's unclear at this point what OSHA will determine as reasonably anticipated, evidence that an employer should have reasonably anticipated a reaction. But it's hard to imagine that written documentation wouldn't be part of that. So I think as an employer, manufacturer, I think it's important to review that written notification where you put on notice of a reaction of a new use of a product that you provide to a downstream user. And what does that documentation look like? And just sort of stay tuned in terms of what reasonably anticipated means, but definitely review that documentation, I think, is a good idea.
Yeah, that's certainly true for contract specified chemical formulations. But again, there may be opportunities to create documentation when selling to, for example, a distributor, to make clear that because you're selling to a distributor, you do not know who's going to buy it and what uses they're going to put it to.
Right. Yeah.
So documenting what you know, documenting what you don't know might be a helpful practice going forward. That's the OSHA 3030. Taylor Johnson, thank you very much for going through the what employers should do section with me. Some great points, and I think that there's probably a great many more. We'd love to hear from all of you as to some of your thoughts about the changes to the rule. Again, this is pre-recorded, so if you have questions and you want to put them in the chat box, we will capture them and we will try and take time to respond to them. If you ever between now and the next OSHA 3030 episode, you have questions about this area of law or any other area of OSHA law, and it's a simple black letter law question or one that we can answer off the top of our heads, happy to chat with you about it. We love chatting about OSHA law, and happy to take time to chat with you about any questions you might have as well. The next episode is going to be held at 1 p.m. on July 24, 2024, always at 1 p.m. Eastern time. We look forward to seeing you then. Don't forget our sister programs, the TSCA 3030, June 27th at 1 p.m., and the REACH 3030 on August 28th of 2024. Excellent programs for those of you who are involved in activities that are subject to compliance with REACH or TSCA. Massively critical programs put on by some world-class experts. So please stay tuned and schedule yourself for those programs, register for them, and spread the good word about all these programs within your organization and at other organizations that are responsible for compliance with OSHA, REACH, or TSCA. Spread the good word to at least 3 people every time you get an invitation so that we can keep these programs going for years to come. Well, I want to thank everyone on the staff here at Keller and Heckman that helped make this episode come together. And to Taylor Johnson, thank you for helping put on another great episode on one of the most important developments that we'll see in OSHA law this year. And to thank you all in the OSHA 3030 community for your support for this episode. All of our previous episodes are available on our website, khlaw.com, and you can catch our rebroadcast as a podcast or on YouTube. Thank you all, and we look forward to seeing you again next month. And until then, stay safe.